Hey everybody, Zach Wolf here with another great Top 5 Tuesday. For this week's Top 5 Tuesday, I'm in front of the beautiful Lee County Courthouse. And this week's topic is trademark law. Let's talk about the top 5 misconceptions people have about trademark law. Number 5 is confusing trademark law with copyright law. So sometimes people will think that when you copy a word or a short phrase that could be copyright infringement. But usually if we're talking short words and phrases, we're talking about trademark law. And what a trademark does that is fundamentally different from, say, something that is subject to copyright is that it is a source identifier. That's the key concept of trademark law. So, for example, if it's McDonald's as a trademark for fast food restaurants, it identifies the source of that restaurant. It has nothing to do with an original work of expression, which is what a copyright covers, or creativity. It's purely a matter of, does this word, phrase, logo identify the source of a product or service? The number 4 misconception about trademark infringement or trademark law is thinking that you can avoid a claim of trademark infringement just by avoiding an identical copy of somebody's trademark. So thinking that if you just change it up a little bit, that you don't have to worry about being accused of trademark infringement. That's not the way it works. In a trademark infringement lawsuit, the issue is likelihood of confusion. So even if your mark is a little bit different from the mark that the senior user owns, you could still cause confusion with that senior user as to sponsorship, approval, endorsement, that sort of thing. So remember, it's likelihood of confusion, and that doesn't require an identical copy of the trademark. The number 3 misconception about trademark law is thinking that the intent of the person who copied the trademark is crucial to trademark infringement. Now, in a trademark lawsuit, the evidence of intent often gets a lot of attention because that's something that's easy for the judge or the jury to grasp and see. You know, for example, if there are emails within one company saying, hey, let's use a trademark that's similar to our competitor who's just killing it and making all this money, that's evidence that is going to carry some weight, especially with a jury. But intent is really only one small factor in a trademark infringement analysis. Courts look at what in the Fifth Circuit they call the digits of confusion, and there are multiple factors that go into whether a trademark is likely to cause confusion. The intent of the defendant is one of those factors, but it's really not the crucial factor, because regardless of what the defendant may have intended, you could or could not have likelihood of confusion. So on the one hand, the defendant might have had a totally innocent intention, and yet you could still have infringement. And on the other hand, the defendant could have intended bad things, but if the defendant made enough changes to the trademark, that might be enough to avoid a likelihood of confusion. The number 2 misconception about trademark law is thinking that registration of a trademark gives you a monopoly over that mark, which could include, a commonly used word or name. Sometimes people will hear about somebody registering a trademark and they'll say, well, how can they possibly register that trademark? For example, Apple is a widely known trademark as applied to computers or cell phones, right? But you couldn't get a trademark for just the word Apple as to apples themselves. That would be what we call generic. So having a trademark having trademark rights, that doesn't mean you have a monopoly over that word. It just means that you have a right to use that word as a source identifier for your particular products or services. Finally, the number one misconception about trademark law, that is thinking that registration of the trademark is what creates the trademark rights. You see this all the time, especially in the press, where they will report that a certain company or celebrity has trademarked a name or word, and they'll use trademark as a verb. Really, trademark shouldn't be used as a verb. It really should just be used as a noun, because the act of registering a trademark with the U.S. Trademark Office, while it does give you certain rights that you would not have absent registration, it does not create the trademark rights. As trademark lawyers will tell you over and over, you create trademark rights through use of the trademark, because it's use of the trademark that creates goodwill in that mark in the consuming public, which makes people associate that trademark with your products or services. So again, you can gain certain rights through registering a trademark, but registration of the trademark is not what creates your trademark rights. So don't fall into that mistake. So those are my top 5 misconceptions about trademark law. If you're a trademark law guru, you probably know a lot of others. If so, leave me a comment and let me know. And hey, thanks for watching.